More news on the Justin Baldoni-Blake Lively front. Her attorneys have apparently just issued new subpoenas, plan to fight back hard against Baldoni. The two sides filed competing letters to the judge, and Lively has set her crosshairs on Jed Wallace, the apparent crisis mitigation expert who filed a lawsuit against her after she claimed he was part of an alleged smear campaign against her. A lot to talk about, and we're going to get into it right now. Okay, so we have some updates in the Blake Lively, Justin Baldoni case we want to talk about right now. First up, Blake Lively's team is indicating they are going on the offensive. And remember, she was the one who first started all this, right? So she filed her initial civil rights complaint with the California Civil Rights Department that matured into then a federal lawsuit, and she has sued Baldoni, his production company Wayfair Studios, and other executives and team members, alleging that Baldoni, her co-star, director of the film It Ends With Us, sexually harassed her and created a hostile work environment on that set, and then proceeded to launch a smear campaign against her in the media and online to destroy her reputation. Now, he countersued, and he filed a suit against not only her, but her husband Ryan Reynolds as well, and argued that she destroyed his reputation, that she did that with false allegations that she weaponized against him, that she coordinated all this with the New York Times to publish these alleged false allegations in a piece about him, that she ultimately took control over all aspects of the film, boxed him out, and then he claims that he hired a crisis management team to not go on the offensive against Blake Lively to damage her reputation, but rather the defensive to prepare if she made claims against him. And by the way, he also sued the New York Times as well for defamation. So there is a lot going on here, a lot of what's been happening, but that is the basic gist. Now, Baldoni has spent a considerable amount of time and effort seemingly litigating this case in the public, right? His attorney, Brian Friedman, doing a number of interviews, allegedly releasing behind-the-scenes footage of a dancing scene in an effort to prove that Justin Baldoni, his client, wasn't acting inappropriately, launching a website that featured never-before-seen text messages between Baldoni and Lively and Baldoni and Ryan Reynolds. The website also featured a timeline of events according to Baldoni, a newly filed amended complaint. By the way, as you know, we have been trying. So after all of that, after this fight has been made quite public, and I've said it before, I'll say it again, it seems that this fight is equally as important for the public, the court of public opinion, as it is in a courtroom. Now, Blake Lively is fighting back. So according to Deadline, her legal team sent out a bunch of subpoenas to companies like AT&T, T-Mobile, Verizon, AOL, Cloudflare, Inc., as well as one of the people that she accused of being complicit in this alleged smear campaign against her, Jed Wallace, a crisis management specialist, who we'll talk about more a little bit later. But her attorneys, Ezra Hudson and Michael Gottlieb, told Dead, quote, "Miss Lively has initiated discovery that will expose the people, tactics, and methods that have worked to destroy and bury her reputation and family over the past year. We will now receive all of the receipts that, unsurprisingly, are nowhere to be found on Mr. Friedman's website. And like Miss Lively, those receipts will have their day in court." And a spokesperson for Lively, and then also, "We look forward to investigating more about Jed Wallace's entire business model and what else he was doing to distract from the very real sexual harassment and retaliation claims made by Miss Lively. We are delighted to be able to start discovery on it." Now, this is big because if you have been following this case, a lot of discussion was centered around what Baldoni and his team presented for the world, the public, the media to see. For instance, apparent messages from Blake Lively to Baldoni where she arguably creates a more relaxed rapport with him, where he perhaps wouldn't have to be mindful of what he's saying. For instance, we have this message purportedly from Blake Lively to Justin Baldoni that was published by Baldoni's side, where it says, "If you knew me in person longer, you'd have a sense of how flirty and yummy the ball busting would play. It's my love language, spicy and playfully bold, never with teeth." So you could argue this is a very provocative way to talk about her character in the film, or what she portrays or wants this character to be like. Then another exchange was presented in this timeline document that was on the website, where Baldoni writes to Lively, "Been deep into writing, really fun with you in mind," and then he seems to backtrack and texts how fun is not the right word, but rather exciting, maybe thinking that fun would come off wrong. But Lively seemingly writes back, "You're safe here." So the idea here is, again, you don't have to worry about what you're saying. Now, I'll make one little point from a legal point of view. That wouldn't negate claims of sexual harassment. You know, somebody might say it's okay to say this, it's okay to say that, but it wouldn't give you free license to just say and do whatever you want. Just want to be clear about that. That's going to be probably put forward in this case. Now, with respect to the argument put forward by Baldoni that Lively wanted to take control over the movie and had her powerful friend Taylor Swift and husband, A-list actor Ryan Reynolds, in her corner, indirectly pressuring him to accept Lively's rewrites of a key scene. Remember that allegation that they talked with him at Blake Lively, Ryan Reynolds' place, telling him how great her rewrites of the scene were? He felt he had no choice but to then accept her rewrites of the scene. Well, the interesting part about that is that Baldoni then publishes another message, seemingly from Blake Lively, where she appears to remark how Ryan Reynolds and Taylor Swift are like her dragons. If you ever get around to watching Game of Thrones, you'll appreciate that I'm Khaleesi, and like her, I happen to have a few dragons, for better or worse, but usually for better, because my dragons also protect those I fight for. So really, we all benefit from these gorgeous monsters of mine. You will too, I can promise you. And then, of course, the dance video montage that was published as well. So Lively alleged that Baldoni went off script, started inappropriately caressing her with his lips, smelled her, broke character. But the behind-the-scenes footage that was released, seemingly by his attorney Brian Friedman, arguably shows Lively breaking character, laughing, making fun of Baldoni's nose, her making a comment about her body makeup and tanner, that is what elicited his comment of, "It smells good." So in other words, everything he did and said, in his view, was explainable, and that she wasn't uncomfortable. Now, there are a lot more messages that were revealed too in the past few weeks, but the bottom line is, it has been a bit one-sided in what was released in the public. So here, it seems Blake Lively's camp is saying, wait till we get full access to communications, posts, social media activity, messages. We will reverse this narrative put forward by Justin Baldoni, all in anticipation of a trial currently scheduled for March 29th, 2026 out in New York. But we aren't at that trial yet, and that now brings me to another update in this case. So, we have a response from the lawyers representing Justin Baldoni, Wayfair, other executives at Wayfair, Baldoni's PR and crisis management specialist, the people that Lively has been suing. We have a response from them. So they just responded to a letter that Blake Lively had sent to the judge. In other words, in order for us to understand what Baldoni and his team just responded, we actually got to go back to the letter that Lively had sent to the judge. So Lively sent a letter on February 10th to Judge Lewis Lyman. So she was asking for an extension of time to file an amended complaint, to file it by March 5th, 2025. Amending the complaint meaning maybe adding defendants, adding claims, including new information or whatnot. Now, in addition, she also asked the court about when she and Ryan Reynolds could file their motion to dismiss Baldoni's lawsuit. They apparently want to file that by March 20th, 2025. So another extension. By the way, there are a number of reasons a case could get dismissed, why you might argue that. So the court, you might say, doesn't have the proper jurisdiction over the case, that this was filed in the wrong venue, that the complaint wasn't properly served. And then there's this one. This is a big one. Failure to state a claim upon which relief can be granted. Essentially, that argument is, even if you take all of Justin Baldoni's claims as true, there's no case here. There's no viable claim. There's no cause of action. Now, the reason Lively and Reynolds say they are entitled to an extension here for, both the amended complaint and the motion to dismiss is because one of the things they argue is that Wayfair and Baldoni, these parties, they requested and were granted an extension to respond to Blake Lively's complaint, so we should get our request. But this is the key, quote, "The modest extension will allow for Ms. Lively to address the extensive new facts and claims at issue in this litigation. Such an extension is also warranted given that after counsel for Ms. Lively informed the court on February 3rd, 2025 that she intended to amend her complaint to add additional parties and claims, one of those intended parties, Jed Wallace, along with his company Street Relations, Inc., filed an anticipatory and meritless 10-page complaint in federal district court in Texas regarding issues that substantially overlap with the issues in this litigation. The additional time requested will allow Ms. Lively to address properly the procedural issues arising from the unmeritorious lawsuit as well." Now this is interesting. So this is the whole Jed Wallace of it all. So as we previously reported on Sidebar, Wallace, who apparently operates a crisis mitigation firm out in Texas, was originally listed as a defendant in Blake Lively's initial CRD complaint, that civil rights complaint that she filed in California. This was a precursor before she officially filed her lawsuit against Baldoni & Co. Now, Lively has alleged that Wallace was instrumental in this alleged smear campaign against. In her filings, Blake Lively's lawyers wrote, quote, "They," referring to Baldoni's crisis team, "also retained subcontractors, including a Texas-based contractor named Jed Wallace, who weaponized a digital army around the country from New York to Los Angeles to create, seed, and promote content that appeared to be authentic on social media platforms and internet chat forums. The Baldoni Wayfarer team would then feed pieces of this manufactured content to unwitting reporters, making content go viral in order to influence public opinion and thereby cause an organic pile-on." Now, Lively's complaint includes what appears to be text messages referencing Jed Wallace. One example is a text in which Melissa Nathan, this is Justin Baldoni's crisis management expert, allegedly told his publicist Jennifer Abel in a text message, "We've also started to see a shift on social, due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan." Or another message where Nathan reportedly texted Abel an apparent quote from Wallace, "We are crushing it on Reddit. Jed." Here's the thing. Jed Wallace wasn't listed as a defendant in Blake Lively's official lawsuit. And because of that, this is now when Jed Wallace, as you just heard from Blake Lively and her team, this is when he filed a $7 million defamation lawsuit against her. That 10-page complaint that Lively mentioned in her letter to the judge, that was filed in Texas court. And in it, Wallace accuses Lively of making unfounded claims against him and his firm, and that he was wrongly implicated in this alleged smear plot. So Wallace contends, Blake Lively, you name me in a CRD complaint for the whole world to see, but you don't actually name me in the lawsuit. The damage was already done. Because as the story spread, he asserts that he was wrongfully named in articles as a defendant due to Lively's complaint, which wasn't true. This complaint reads also, Lively or her agents provided the precursor, meaning the complaint, to various media entities for out-of-court republication. And because of the allegations contained therein, it made headlines around the world. According to Elle magazine, which linked to the precursor document, as did many other media, Wallace and Street were widely reported to be defendants in the formal lawsuit, although they were not. The confusion having been sown by the precursor. Indeed, having been the one harassed, she knew the exact opposite. Neither Wallace nor Street had anything to do with the alleged sexual harassment, retaliation, failure to investigate, or aiding and abetting the alleged harassment or alleged retaliation. Neither could they have breached a contract with Lively because no such contract exists, and they were not involved in any of the events depicted in either the precursor, where they were named as defendants, or the formal lawsuit, where they were not named, which could give rise to a duty toward defendant negligence or any other tortious conduct, false light, intentional infliction of emotional distress, or interference with prospective economic advantage. Actually, I will tell you what, we're going to talk about Wallace a little bit later on because we also got our hands on something else that we haven't had an opportunity to go through. We'll talk about that, but going back to Lively's letter to the court asking for extensions of the deadlines, it actually reads in a footnote, quote, Mr. Wallace's filing presents serious issues with respect to jurisdiction, venue, and claims, and was motivated by, in Mr. Wallace's counsel's own words, the fact that Miss Lively had indicated she intended to name him in yet another lawsuit. Let me explain that. So she is seemingly indicating how she will fight back against Wallace's lawsuit. One of the things that she seems to be calling out or alluding to is the fact that in his lawsuit against her, Wallace had asked as a form of relief for the court to issue what is known as a declaratory judgment. So in this case, it appears he wanted the court to step in and issue a formal statement, a formal order declaring that he was not involved in any way in any of the alleged harassment or retaliation or smear campaign against Blake Lively, that he's in the clear. And that seems to be so he can't be named as a formal defendant by Blake Lively in an amended complaint. Again, more on him a little bit later, but going back to Blake Lively's letter, in terms of when Lively and Reynolds can file their motion to dismiss, again, they want to be able to do so by March 20th. They've argued that schedule aligns with the Wayfarer defendants because that's the deadline by which Wayfarer and Baldoni can file their motion to dismiss Lively's complaint. So in other words, this should all be on the same track. There's also more of a discussion on the federal rules on deadlines and when to file certain papers. I'm not going to bore you with all that. You get the general premise of what's being argued because that now leads us to how Wayfarer responded. So Wayfair and Baldoni and the team, they filed a letter with the court on February 11th. And here is what is said in their response. They write, quote, "Notwithstanding the Lively party's inexplicable refusal to consent to a similar extension requested by the Wayfair parties in the throes of the Los Angeles wildfires, the Wayfair parties have no objection to the extension sought by the Lively parties." First off, that is a really pointed shot there. You see, it was reported that in a prior filing, Baldoni's team accused Blake Lively and her team of really acting in bad faith. It reported that in one filing they wrote, "The Lively's party's counsel refused to consent to an extension of time, contending that counsel requested that the Wayfair parties waive service, but no waiver was excluded. Insensitively, the Lively parties ignored the effect of the Los Angeles wildfires on Mr. Friedman and his law office." According to In Touch, Baldoni's attorney, again Brian Friedman, lost his home during the LA wildfires, and Lively and her team, the argument was, didn't even appreciate that complication in this litigation. In fact, according to the timeline file, the timeline document that was published on that website that was launched by Baldoni's side, it reads, quote, "January 7th, 2025, Lively attempts to serve Baldoni and team during the Los Angeles wildfires, going as far as to serve a member of Baldoni's team while they attempted to evacuate with their small child." So in this new letter, Baldoni and Wayfair are bringing it up again. They're like, even though you didn't give us the proper accommodation given the hardships we were going through, tell you what, we'll agree to your extensions, we'll agree to your deadlines. But then the letter continues, quote, "However, if the court extends the Lively parties' deadline to amend their complaint to March 5th, 2025, the Wayfair parties respectfully request that the court extend the Wayfair parties' deadline to respond thereto to April 16th, 2025. And then it goes back to Jed Wallace once again. The letter reads, "Unfortunately, the Lively party's letter goes further than a simple request for an extension of time, leveling unnecessary and baseless attacks on non-party Jed Wallace and the litigation pending against Miss Lively in the United States District Court for the Western District of Texas. What the Lively parties conspicuously fail to mention is that the now pending litigation in Texas was precipitated by Miss Lively, who initiated legal action against Mr. Wallace in Texas State Court on January 21st, 2025, approximately 2 weeks before he filed his federal lawsuit in response. While the Lively parties now claim that Mr. Wallace's Texas action suffers from serious issues with respect to jurisdiction, venue, and claims, in Miss Lively's verified petition seeking a pre-suit deposition of Mr. Wallace, Miss Lively acknowledges that jurisdiction in Texas is proper given Mr. Wallace's domicile. A true and correct copy of Miss Lively's petition is attached here too as Exhibit A." Now, let me just explain what's going on here. I'm going to get to that exhibit in a little bit. We haven't really talked about it before. But essentially what's being argued is that before Jed Wallace filed his complaint against Blake Lively, she had actually tried to depose him. And that is really interesting because Baldoni and his team continue at her writing. Notably, in her pleading, Miss Lively concedes that she lacks sufficient facts to state a claim against Mr. Wallace, hence the need for pre-suit discovery. In addition, while the Wayfair parties strenuously object to the Lively party's assertion that Mr. Wallace's lawsuit is meritless or unmeritorious, it bears emphasis that Mr. Wallace is represented by separate counsel in that matter, and he's not a party in any case before this court. In other words, Blake Lively, why are you mentioning Jed Wallace in your letter? Now, before I get back to that exhibit, and I really want to talk about it, and we'll talk more about Mr. Wallace, based on the court's docket, it seems the judge here has made a decision on all of these deadlines and extensions. So the docket reads that the time to file an amended complaint by Blake Lively has been extended to February 18th, 2025. Initially it said the 17th, but apparently there's some sort of holiday. Remember though, Blake Lively had wanted March 5th, but according to this order from the judge, Lively didn't provide good cause for why she would be entitled to extending it that far out. However, Blake Lively did get a win. The judge granted her an extension to file her motion to dismiss by March 20th. And by the way, that is good for all of us to know these dates because we're going to keep an eye out for them. Little legal inside baseball thing here, at least from my experience in litigation. While the attorneys can obviously file an amended complaint or a motion to dismiss before the deadline, us lawyers, we love to write, we love to rewrite, we love to wait for additional information, and sometimes we will wait till the very last minute before filing a document. So remember those dates of February 18th, March 20th, we should be getting those documents at around that time. Now, Before we wrap things up, I want to talk about that exhibit that I mentioned regarding Jed Wallace. So one of the questions becomes, why didn't Blake Lively name Jed Wallace as a defendant in her formal lawsuit, right? Well, according to Jed Wallace, and what also seems to be from Baldoni and his side, the answers may lie in her formal request to seek a deposition from Jed Wallace out in Texas. That is part of this exhibit. It's called a Rule 202 deposition under Texas law. Rule 202 deposition under Texas civil procedure allows a person to request a deposition before filing a lawsuit. It's typically used to investigate claims, gather evidence, identify potential defendants. Now, we haven't really broken down this specific petition before, so I want to do that. First off, as I mentioned, Baldoni and Wayfarer in their letter to the judge, it does say in this document from Lively, this court has personal jurisdiction over Mr. Wallace because he is domiciled in Dripping Springs, Texas, which is within Hays County, Texas. In other words, how can you argue, Miss Lively, that Wallace improperly filed a complaint against you in Texas because it lacks proper venue or jurisdiction when you just acknowledge the opposite? Interesting argument. Now, this petition for Wallace's deposition, Blake Lively needed to give a reason for why she wanted him deposed, right? And it lays out her belief on what she says is Wallace's alleged involvement in this smear campaign. Quote, on information and belief, that basically means I don't have the evidence to prove it yet, but based on what I have seen and what I've heard and been told, I believe it to be true. On information and belief, TAG, that is the crisis management firm that was operated by Melissa Nathan, one of the defendants in this case. On information and belief, TAG engaged Mr. Wallace to assist them in their unlawful retaliatory social combat campaign on behalf of Wayfarer Mr. Baldoni against Miss Lively by implementing the social manipulation campaign across various social media platforms, including Instagram, Reddit, and TikTok. On information and belief, in August 2024, in the lead up to the film's premiere, and in the weeks that followed, Mr. Wallace worked remotely from Dripping Springs, Texas at the direction of Miss Nathan, TAG, and Miss Abel on behalf of Wayfarer and Mr. Baldoni to undermine the credibility of and retaliate against Miss Lively through this social manipulation campaign. And then Lively cites a specific alleged instance. Quote, on August 7th, 2024, Miss Abel inquired about the cost of social media mitigation and proactive fan posting to counter the negative press surrounding Mr. Baldoni, and whether what she had discussed with Miss Nathan earlier regarding social manipulation from the separate team based in Hawaii and included in that fee on information and belief, the referenced team based in Hawaii worked with Mr. Wallace and or at his direction. The petition goes on information and belief, Mr. Wallace was in regular contact with not only Miss Nathan, but also other executives of Wayfarer. For example, on August 18th, 2024, Miss Nathan texted Miss Abel that as opposed to using bots, the other team is doing something very specific in terms of what they do. I know Jamie and Jed connected on this. Jamie referring to Jamie Heath, CEO of Wayfarer. However, that is not the only connection that Lively establishes. She also claims that Baldoni's attorney, again, Brian Friedman, also represented Mr. Wallace and that they have a, quote, close personal relationship. And that arguably proves Wallace's connection to Baldoni and the other defendants in Lively's action. This petition says in an August 13th, 2024 text, Miss Nathan inquired about whether she should create a signal thread between herself, Miss Abel, and Mr. Wallace, quote, in case you need Mr. Wallace to connect you to Mr. Friedman because they're very close. Now, here is where things get very interesting. In this petition, Lively acknowledges that Wallace was not named as a defendant in her official complaint, her official lawsuit. But there's no real explanation that I saw in this document for why. But it does say, quote, petitioner now seeks an order from this court authorizing the taking of a deposition to investigate petitioner's potential claims against him. And that has been jumped on by Mr. Wallace because he argues she doesn't have the facts to support her allegation that I was part of this whole purported smear campaign against her. And then there's this. So Lively in this petition claims that she believes there was a smear campaign directed against her, but Friedman, the attorney opposing her, Baldoni's attorney, she says he has made the claim that no campaign actually existed, that no campaign was actually carried out. He further has threatened to file suit against anyone who pursues a lawsuit against his clients, including Mr. Wallace, based on such allegations. Accordingly, a Rule 202 deposition would serve the interest of justice by allowing petitioner to investigate the scope of Mr. Wallace's conduct as described herein, and to reduce the risk of inviting frivolous lawsuits by Mr. Friedman. Now, while Blake Lively seems to be arguing, okay, in the interest of me fully proving my claims, especially when Brian Friedman is threatening to sue me if I pursue my case against Wallace, give me the chance to depose him. Sit him down, let me ask him questions, let my attorneys ask him questions, rather, and I will show you, court, that I have the goods. His answers will help prove that he was a part of it. On the other hand, the other way of looking at it, Mr. Wallace, in his lawsuit, and Baldoni and his team in their letter to the court seem to be saying, the fact that she's asking for a deposition right now proves she has nothing. In other words, they're arguing this is a sign that she improperly initially listed Wallace as a defendant without having sufficient facts to back it up. Interesting argument from both sides, but there you go. Some updates in the Justin Baldoni, Blake Lively ongoing legal saga, and we will make sure to continue to follow it for you.